Yes, I know.
Well, ladies and gentlemen, it is just past 6. Thank you very much for coming to this public lecture, which I think is of great interest, not only to the medical profession, but to the legal profession as well. Now, if I might invite those sitting in the back to consider coming forward to the more expensive seats up front, the better, so that James can see you and hear you when you ask questions of him. It will also allow latecomers to sneak in quietly and seat themselves. Plenty, I think, at the sides here in front and in the middle. Well, first, 2 introductions. My name is Terry Khan. I am the co-director of the Center for Medical Ethics and Law of the University of Hong Kong. And in front, the gentleman who has been making comments is my worthy co-director, Dr. Philip Bay. If Dr. Bay could just stand up. So the 2 of us are responsible for what goes right and often, I guess, goes wrong with the stuff that we organize. Just one line about the center. It is a joint center of the Faculty of Law and of the Li Ka-shing Faculty of Medicine. To see what we do and what we want to do, you can take a look at our website. Today we have the great pleasure of having a very distinguished guest with us, Mr. James Badenode, QC. The significance of today's talk is that just under 2 months ago, on the 11th of March this year, the UK Supreme Court delivered a decision in a case called Montgomery and Lanarkshire Health Board, which basically overturns more than 30 years worth of English common law jurisprudence. The significance of this decision is simply that Hong Kong generally follows English common law. So while we do not know what will happen or what will be decided in the Hong Kong courts, we now have this case that they will have to consider if push comes to shove when someone raises a claim on failure of adequate disclosure. Mr. Badenoch QC took silk in 1989, and he was the lead counsel for the successful plaintiff in this case that I spoke of, the Montgomery case. He has specialized for over 35 years in clinical negligence, medical law, and medical disciplinary cases. He has appeared in a succession of major cases in the House of Lords, the UK Supreme Court, the Privy Council, the General Medical Council of the UK, the GDC, and also in the High Court and the Court of Final Appeal of Hong Kong. He is a bencher of Lincoln's Inn, a Deputy High Court Judge since 1994, a President of the Mental Health Review Tribunal since 1999, a Fellow of the Royal Society of Medicine, Chairman Emeritus of the Expert Witness Institute, and has been a recorder of the Crown Court from 1987 to 2012. I have his CV in hand, and it's really far too long for me to read out in its entirety. So I think I will not provoke you that way. We also have with us today 2 very distinguished panelists, Professor Felice Learmark and Mr. Chris House. Sometimes papers get lost. Very lost. Well, Professor Felice Learmark was chair professor and head of the Department of Psychiatry at HKU. She was a previous dean of the Faculty of Medicine at HKU, as well as a special advisor to the Vice Chancellor. She's a past president of the World Psychiatric Association, an advisor to the United Nations and the World Health Organization. Professor Lian Mak is also the immediate past chairman of the Hong Kong Medical Council and still sits on many of the disciplinary committee hearings. She is currently in private practice. Mr. Chris House is a partner in the law firm of House Williams Bowers. He has more than 35 years of legal experience. He built the Hong Kong office of Richard Butler, and he was senior partner and managing partner of that office from 1983 to 2011. Chris leads the medical legal team with fellow partner David Kahn. David is somewhere in the audience. David? There he is in the middle. They advise doctors, dentists, and their indemnity provider, the Medical Protection Society and Dental Protection Limited, as well as private hospitals and other healthcare professionals. Chris also advises private hospitals, corporate healthcare providers, and pharmaceutical companies on issues relating to the import and distribution of drugs and pharmaceutical products, drug liability claims, and other regulatory matters. Well, I will now introduce you to invite Mr. James Badenode to take the stage and get to the substance of what we all are waiting for. Mr. James Badenode.
Well, thank you, Terry, for that very kind introduction, and thank you for the invitation. Thank you to Terry Kahn, Michael Hoare, and Ron Zeman, who I think has been instrumental in seeing me come here for this lecture. It's a great honor to be here, and it's a particular pleasure and honor for me because my grandfather, Lancelot Forster, was the first professor of education at Hong Kong University, and my mother was born and brought up here, and I was brought up on tales of old Hong Kong. What I can tell you is that I'm very proud of that association with Hong Kong, and as is my mother. And my grandfather told me many stories of his life here before the Japanese took him into Stanley Camp, where he was imprisoned after the Japanese occupation. It's a proud association in our family, and I'm delighted to carry on in a very modest and minor way the tradition that he started in our family. I turn to the case in question. The decision of the UK Supreme Court in Montgomery against Lanarkshire Health Board is a momentous one. It's momentous because it has major implications for the practice of doctors and surgeons in the matter of disclosure of information to patients for the purpose of consent to treatment. It overturned the long-standing and much-cited decision on consent of the Judicial Committee of the House of Lords, of which the Supreme Court is the Lord's successor, the case of Sidaway and the Board of Governors of Bethlehem and Maudsley Hospitals, which was decided by the Lords as long ago as 1985. That decision, I hope you don't mind if I hurry a bit, I've got quite a lot to cover. I haven't got PowerPoint, I haven't managed to drag myself into the 21st century. Indeed, some might think I haven't got into the 20th yet, but you'll have to bear with me if I go a bit fast. The decision in Sidaway has been the subject of whole chapters in textbooks. It's been much criticised over the years by academics and practicing lawyers around the world, and it's been rejected in the courts of Australia, Canada, the USA, and I venture to think in all other jurisdictions which do not precisely follow the English common law. It has, of course, retained its power in Hong Kong. Its UK reversal is momentous for the inroads it's made on the dominance of the Bolam principle, the name for the test of negligence in all aspects of clinical practice, which until now included disclosure of information, which was established by the famous case of Bolam against Free and Barnet Hospital Management Committee in 1957, which had prevailed until this day. Some of you in this room, I know, have heard me before on my hobby horse, which is that Bolam needs to be consigned to the dustbin of history. And in a small way, this, or perhaps not so small, this case of Montgomery is one of the nails in the coffin of Bolam, as has been acknowledged by a very senior judge, whom I'll quote at the end. The decision put shortly was that in respect of alleged negligence in the adequacy of a doctor's information, that's to say information disclosure for the purpose of patient consent, the Bolam test will no longer apply, as it does still in cases where diagnosis or treatment are impugned. By the test of Bolam, the issue was determined solely by the answer to a simple question, and it was this: does the disclosure made by the doctor, or is the disclosure made by the doctor, sanctioned as acceptable by at least a responsible body of the medical profession, even if a minority one? If such a body could be found, it was by the authority of Sidaway a complete defence to an allegation of breach of duty in failing to provide enough information for valid consent. It need hardly be said that among doctors there has always been found a wide range of idiosyncratic views about how little or how much to tell their patients, views which owe nothing to science or learning, but only to personal prejudices on the part of the doctor in question, and which, because of their wide variety, made for real uncertainty about the supposed rights of patients to information disclosure. At the risk of condescension, may I deal in a bit more detail with Bolam itself, first expressed in the 1950s and applied over the ensuing years, with this important observation, which people don't often remember. Bolam was a decision following directions on law made by a jury, because in those far-off days, civil actions for damages, even those for professional negligence, were decided by jury trial, as they are to this day in North America. I heard the president of the American Trial Law Association give a speech in London about how he performs his final address to the jury. And after describing all his overhead projections and his life-size working models and all sorts of things which I found very strange, he then said, "At this point I usually cry." He said, "I think of my dear late sainted mother, a wonderful woman, and the tears flow very readily, and I find this very effective in medical negligence cases in front of a jury." Now, funny though that is, it's also very chilling, isn't it? And thank goodness that we've long since abandoned jury trial for, in particular, professional negligence, where the issues are of such great importance, not only to the alleged victim of negligence, but also to the professional person whose practice is impugned. Let me tell you about the facts of Bolam. Hector Bolam, the plaintiff, I bet you didn't know his name was Hector, not many people do, was very depressed, and he was even more depressed when the treatment he was given caused him injury and then caused him to give his name to a principle of law which caused him to lose his case. His doctors decided to treat him with ECT, electroconvulsive therapy, by which powerful electric shocks are administered through paddles to the patient's head. Those shocks predictably produced powerful muscular convulsions in the patient, which in his case threw him bodily from the couch onto the hard tiled floor of the clinic and caused bilateral leg fractures which crippled him for life. He sued his doctors, and he called expert psychiatrists who said that due care for his proper protection when he was given these electric shocks required that he either be strapped to the couch to restrain his body or sedated so that his muscles didn't convulse when the shocks were applied. Strange as it may seem, the defendants found and called other ostensibly responsible psychiatrists whose expert opinion was against the use of sedation or straps, on the purported grounds, which may seem to my audience illogical, that those measures themselves carried risk to the patient. I've struggled to imagine what those risks might be, and I still haven't come up with them, unless I suppose you tied the strap so tight that you strangled the patient, which was surely something they could have avoided doing with reasonable amount of care. They thus established that there was, purportedly, a school of thought, medical thought, which at the time would support and endorse as acceptable the administration of shocks without any such protection. In respect of that evidence, the direction of the trial judge, Mr. Justice McNair, to the jury has become extremely well known. But if you don't mind, I will quote the passages from his judgment, or his directions to the jury rather, and the judgments of appellate courts, which underlined, endorsed, and ingrained the Bolam test in the medical law, which is followed in England and here. What McNair J. said was this: a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular art. Putting it another way round, a doctor is not negligent if he is acting in accordance with such a practice, merely because there is a body of opinion which takes a contrary view. That direction proved fatal to Mr. Bolam's claim. It echoed a judgment in Scotland from Lord President Clyde, in the case of Hunter and Hanley, which also became very well known historically. I should say, if I may pause a moment to explain why I ever came to be in this case at all, because as you may have noticed, it's a Scottish case. The Scots are proud of having very different legal procedures from England, and indeed, in many respects, an entirely different legal system. But it is the case that they follow the English common law in the matter of negligence. I was asked whether I would lead in this case when it came to the Supreme Court, about which I was very concerned, because I thought I'd be treading on many Scottish toes, they being very sensitive, understandably, about their allegedly vastly superior bar and vastly superior legal system and vastly superior procedural rules. But I was assured that of two things. One, that the case we were seeking to overthrow Sidaway was an English House of Lords decision, which of course is true. And the other is that I had become well known, if not notorious, for my dislike of the application of Bolam across the board. And I know that some of you heard me in Hong Kong speak on that very subject a couple or so years ago. And so in the end, somewhat reluctantly and concerned about treading on toes, I agreed to do it. And I have to tell you, I did tread on some toes, as I learned later, and there's not much I can do about it now. But by and large, it was accepted in Scotland that it was reasonable enough to ask me to do it. Not everyone, sadly, agrees. I think it's worth just touching on what Lord Scarman, the radical law lord, said about Bolam in the case of Maynard and the West Midlands Regional Health Authority in 1984. He was, in this regard, a supporter of Bolam in reference to clinical practice. When it came to Sidaway, as many of you will know, he was the dissenting law lord, who himself argued very strongly that Bolam could have no proper place in relation to information and consent, for the very simple reason that the patient has the right to decide what shall be done with his own body, and the other simple reason that the decision to consent is the patient's decision and not the doctor's decision. So he, in due course, is the one who was vindicated by the Supreme Court in Montgomery. But what he said in support of the general principle of Bolam was this: a case which is based on an allegation that a fully considered decision of two consultants in the field of their special skill was negligent clearly presents certain difficulties of proof. It is not enough to show that there's a body of competent professional opinion which considers that theirs was a wrong decision, if there also exists a body of professional opinion equally competent which supports the decision as reasonable in the circumstances. Differences of opinion and practice exist and will always exist in the medical as in other professions. There is seldom any one answer exclusive of all others to problems of professional judgment. A court may prefer one body of opinion to the other, but that is no basis for a conclusion of negligence. Now, just pausing a moment, I have to say this about Bolam, that we all tend as lawyers to think that it is exclusively applied to the medical profession. My experience is that that is almost entirely true. Technically, however, it has in the textbooks been recognized as applying also to any professional activity, whether it be architecture or designing bridges, whatever it might be. The fact is, however, that over the years, as many of you will know, in relation to other professions, judges have not been willing to apply Bolam's simpliciter and to allow a minority body, however apparently small and possibly idiosyncratic or even eccentric or maverick, to carry the day. In other professional cases, generally speaking, judges have simply not been willing to do that, and they've exercised their normal judicial function of deciding which they prefer and making their decision in the case accordingly. Well, there it is. The passages establish an approach to the standard of care expected of and imposed upon medical practitioners, which, in my opinion, is and has been exceptional in the English law. Almost entirely exceptional, not totally, I have to concede. In almost all other cases where negligence is disputed in some specialized field of human endeavor, whether it's navigating a tanker or giving financial advice or legal advice for that matter, it's the judge's function to determine whether negligence is proved or not. He hears the opposing experts who respectively condemn or approve, He decides which he finds the more convincing. He prefers one, he rejects the other, and decides the case accordingly. And all of you, those who practice in the law, will be very familiar with that perfectly standard process, which is the judge's job. Although the Bolam test, as I say, has been invoked in relation to other professions, it's only the medical profession which, down the years, has been able to place real and often decisive reliance upon it. Now, the well-known Hong Kong case of Edward Wong Finance and Johnson, Stokes and Masters in 1984 is instructive in this regard. The Privy Council held, in that case, that even though the completion of property sales in Hong Kong, in what was termed Hong Kong style, was almost universally adopted by local solicitors, and therefore obviously accorded with and was sanctioned as acceptable by a vast body of professional opinion in Hong Kong, the Privy Council nevertheless held the defendant solicitors liable for negligence because in the process in question there was an obvious risk against which they had not properly guarded when following it. So there, almost universal approval, and yet the judges held that there was negligence proved. By contrast, the Bolam principle, as strictly applied, simply disqualifies the judge from performing the ordinary judicial function and effectively appoints the medical profession judge in its own cause to arbitrate the issue. That, in modern thinking, is something which we ought, it seems to me, and I've been saying so for some years, very strongly to discountenance and disapprove. In consequence, a Bolam defence will succeed even if those who purportedly sanction the performance as acceptable are a very small minority indeed, provided only that they're not dismissed by the judge as not respectable, not responsible, or even incompetent. And yet those labels are labels which judges would very seldom feel able, as a lawyer, to attach to a body of doctors or to an expert witness, unless he seems transparently a fraud. In other fields, he doesn't have to attach those damning labels to the expert whose evidence he rejects. He simply says, I prefer the other expert. I'm going to take a moment or two, if I may, to speak of personal experience of the injustice which, in my view, Bolam historically caused. In my 46 years in practice at the bar in England, I'm now embarrassingly old. I've seen surprising expert medical contentions frequently made under the guise of respectability. They used to turn out some old dinosaur doctors to give expert evidence in defence of almost anything. One week turning up to defend a neurologist, and next week to defend a gynecologist, and say, man and boy, that's been perfectly acceptable as far as I'm concerned, and I know a lot of people who agree with me. Well, that wasn't a good thing, in my view, and I suffered under it in a number of ways. There were some consequently surprising dismissals of perfectly meritorious claims by patients who had suffered harm at the hands of doctors. However, over those 46 years, I have also observed that whereas the Bolam test was originally enjoying a real supremacy, which lasted for a long time, that was followed by a gradual dilution or erosion of its power, as exemplified in the Badenoch decision, to which I will return. Now, in Montgomery, it's removed altogether, at least from the area of medical law which governs the doctor's duty of disclosure and the consequent validity or otherwise of you, the patient's consent to proposed treatment. I illustrate the supremacy of Bolam with a case that scarred on my soul, and I think one or two of you in the room may have heard me talk of it before. I apologize for repeating it, but it still causes me great anguish. I acted for a child who had suffered catastrophic hypoxic ischemic, that's asphyxiation, brain injury, during his delivery, surprisingly, a delivery by caesarean section. The obstetrician was lifting the baby out through the uterine incision, holding it by its feet. As he was doing so, and before the head was out, the uterus went into, it's a rare circumstance, the uterus went into a sudden strong spasm, closing itself around the baby's after-coming head, thus cutting it off from all supplies of oxygen, and it was now in danger of asphyxiation. There was, according to expert evidence, which was extremely easy to find right and to accept, a simple measure which would have dealt safely and at once with this extreme emergency, namely to cut a second vertical incision at right angles to the first in the uterus, thus opening it out, cutting through the muscles that were in spasm, which would immediately have released the baby's head and saved it entirely from any harm at all. The obstetrician, however, did not take that course. Instead, he chose to wait and wait and wait until the uterine spasm relaxed, something which was bound in due course to happen, but the time scale for which was completely unknown to him and in advance unknowable. Tragically, by the time the head was released, the baby was all but dead from asphyxia and his brain was terribly and irreversibly damaged. The plaintiff's obstetric evidence was perfectly simple, and any of us in the room could have given it, couldn't we? Just cut the vertical incision, get the baby's head out, save it from this terrible fate, and then sew up the uterus afterwards as best you possibly can. However, that evidence having been given for the plaintiff, the defendant managed to find and call 2 professors of obstetrics from a very famous London teaching hospital. They condemned the vertical cut. It was Guy's Hospital, by the way. They condemned that vertical cut on the grounds that it was, quotes, an unacceptable mutilation of the uterus, a phrase which they were able to point to in an old textbook of obstetrics called McGillivray. This, they said, could, and I quote, threaten the mother's future fertility. I add what you are adding in your own minds, I'm sure, that this opinion thus expressed carried the inevitable and necessary implication that a perfectly viable existing child who was full-term, could legitimately be sacrificed in order not to mutilate the uterus of the mother and in order not to risk the possibility that she might in future wish to have a notional further child. Well, you've obviously guessed the outcome of this, haven't you? Because I've told you it's scarred on my soul. The judge, Mr. Justice Michael Wright, now retired, but I bump into him occasionally and frown at him, considered himself on that evidence bound by the Bolam principle and dismissed the claim. I was young, and Bolam was still at the time in its pomp. It was supreme. But, with hindsight, I should have appealed that decision, though the child's family were understandably reluctant to have anything at all more to do with the law. Had I done so, I have no doubt at all that the judges in the Court of Appeal, and the Lords, if it came to that, would have reversed it and struck down any application of Bolam which defied logical analysis, which is the proviso to Bolam which came to be formulated much later by Lord Brown-Wilkinson in the famous Badenoch case in 1998. Because I didn't appeal that case, the facts of which were so strikingly bad, the pace of change of UK medical law remained very slow indeed. I could and should have accelerated it. The Bolam proviso, which had been long applied unofficially by some judges to so-called Bolam defences, reached its open acknowledgement in that case. It was called Badenoch and the City of Hackney Health Authority in 1998. That case authoritatively established that a defence of professional approval or sanction of allegedly negligent performance would not meet the famous Bolam test if it was, quotes, incapable of withstanding logical analysis. Hear that, Mr. Justice Michael Wright? I'd like to rub his nose in it. This recognition of an important modern principle, in my view, reflected a change in society's attitudes and was long overdue. I note here, by the way, the possibility that Lord Brown-Wilkinson himself did not consider Bolam properly applied to questions of information disclosure, since at one point in his judgment he used these words, "I am not here considering questions of disclosure of risk." Well, I think many of you will agree with me that over the years before the Badenoch proviso was expressed in 1998 in that case, good judges were always willing to temper Bolam with reason. I say good judges, and you can tell who I exclude from that description. Finding where the evidence compelled it that the asserted approval of an ostensibly responsible medical body must be rejected as being illogical. Were that not so, contested medical negligence cases would never, almost never, have been won by a plaintiff, since in an adversarial contest, a trial, it always and by definition involves expert defence evidence of a supportive kind. And yet it is the fact that in decisions of judges of an independent mind, the claims with merit could succeed and did succeed before Belitho was established. So, in Sidaway, here we come to the crucial issue in the case of Montgomery. Should it still apply to issues of information disclosure for the purposes of consent? The law lords in that case had held, some people say only by a majority of 3-2, others say unanimously, and certainly on the face of it, it appeared to be a unanimous decision. Indeed, none of them actually said that Bolam should not apply to disclosure, but the fact is that some of the law lords, in an ambiguous way and without unanimity of reasoning, could be said in effect to have forecast the findings in Montgomery so many years later, 35 years later. What Lord Diplock said, and I just pause to describe Lord Diplock for a moment, he was a judge of the old school. I have to confess that I do not turn to his opinions willingly for enlightenment on any vexed area of the law. As a personal anecdote, you might be amused to know that Lord Diplock lived in the latter years of his life in a flat above my chambers in the Temple in London. Because he was a target of the IRA, terrorist organisation in Ireland, he had certain special protective measures in place. I should tell you that a famous Irish terrorist called Quinn had been arrested with all sorts of plans for terrorist activity on the mainland, and in his pocket, among other things, was a diagram of my chambers building with the time it took for the lift to go between each floor, thus making them fairly certain that Diplock was a target for this reason. He was the progenitor of what are called the Diplock courts in Northern Ireland, whereby terrorists on criminal charges were tried by judge alone without a jury, something which terrorists took against in quite a strong way. And so we had, for about 7 or 8 years, armed policemen living on the staircase of our chambers. And if you went up there in a hurry, a big man would jump up and thrust a gun in your face, which caused many a fluttering in the hearts of those of nervous disposition, especially those who ran up the stairs unaware that they were about to be confronted by a gun. Anyway, what he said in Sidaway was to ring down the years, and it's very important that I cite it. He said this: the message of the Bolam test is that the criteria of the duty of care owed by a doctor to his patient is whether he has acted in accordance with the practice accepted as proper by a body of responsible and skilled medical opinion. To decide what risks, the existence of which a patient should be voluntarily warned, and the terms in which such warning, if any, should be given, having regard to the effect that the warning may have, is as much an exercise of professional skill and judgment as any other part of a doctor's comprehensive duty of care to the individual patient. And expert medical evidence on this matter should be treated in just the same way. The Bolam test should be applied. His view of the merits or otherwise of full disclosure to patients was uncompromising and was a prime example of outmoded attitudes, and I'll come to them in more detail shortly. What he said about it was this: the only effect that the mention of risks can have on the patient's mind, if it has any at all, can be in the direction of deterring the patient from undergoing the treatment which, in the expert opinion of the doctor, it is in the patient's interest to undergo. I ask you, what could more revealingly express a condescending and paternalistic approach to a patient than this from a distinguished law lord? He assumes in the patient a lack of capacity for rational and independent thought, unquestioning subservience to the doctor's superior status, and abject surrender of personal autonomy. I make no excuse for saying it in those strong terms. There's no way around it. That is exactly what his statement assumes. Most unattractively to modern thinking, dear old Lord Diplock went further. He made an express exception to this rule for people such as himself. what he said, literally, I mean it, what he said was this: but when it comes to warning about risks, the kind of training and experience that a judge will have undergone at the bar makes it natural for him to say correctly, it is my right to decide whether any particular thing is done to my body, and I want to be fully informed of any risks there may be involved, of which I am not already aware from my general knowledge as a highly educated man of experience, so that I may form my own judgment as to whether to refuse the advised treatment or not. And he then added with apparent distaste, no doubt if the patient in fact manifested this attitude by means of questioning, the doctor would tell him whatever it was the patient wanted to know. So, while Lord Diplock had the independent right to the full facts and the right to apply to them his own reasoning when deciding whether to submit to proposed treatment, the ordinary patient, almost everybody else, because there are very few of Lord Diplock's exalted status, the ordinary patient had no right to any such information unless he had the temerity to ask his doctor direct questions. And in this latter regard, it's quite plain that in the age of deference, now that's an age which I think is largely past now, I think possibly my generation, I was born in 1945, I think in my generation we were probably the last to have the vestiges of deference to our elders, our betters, and so on in society. Certainly in Northern Europe, I think we were the last, and my children aren't in that category at all. In that age, it was a very rare patient who dared or thought it proper to question his doctor at all, and that attitude is still largely found among the oldest in our populations. So, while the reasoning of Diplock was direct and uncompromising, and I would add plainly wrong, there were in the varied reasoning of the other law lords ambiguities and inconsistencies which exposed, quite frankly, the intellectual gymnastics which were required to fit Bolam to disclosure. Notable among them was Lord Bridges' asserted exception to the rule by which the law would impose on the doctor to reveal a risk of the magnitude of 10%. This arbitrary figure was obviously unrelated to the true concerns of a patient. A reasonable patient will be less concerned about major risks of minor harm than with risks, however small or minor, of major harm. Yet the 10% rule was opportunistically relied upon down the years, not least and particularly spuriously, as will be seen, by the defence in Montgomery. The essential fallacy in Sidaway, as the Supreme Court in Montgomery eventually agreed and accepted after all these years, lies in equating A, the doctor's decisions about treatment and about the risks and benefits of treatment and of any alternatives, with B, the patient's decision, which is his and his alone to make, whether to submit to that treatment or to any alternative or to refuse treatment altogether. The fallacious elision of these two quite different decision-making processes had been acknowledged in earlier decisions in other jurisdictions, to which I will return. Yet Sidaway prevailed for 30 years. And the truth is this: there was much consequent injustice to patients, whose access to information on which to base consent was controlled and confined, as often it was, by the persistence of a paternalistic and patronizing approach of many doctors, the approach which Lord Diplock so strongly approved. That was what we argued against in Montgomery, and that was the attitude which Montgomery has rejected. Before I address the development in more detail and the changes in society, I think it would be interesting to you to hear the facts of Montgomery if you don't already know them, facts which will, I know, at least surprise you and possibly astonish you. This is because they are extreme, and principally because, as the Supreme Court by their decision accepted and agreed, their extremity invites the question of how on earth the case came to be defended at all. That this was their conclusion is apparent from something that the Supreme Court did which they almost never do. They rejected and reversed the trial judge's findings of fact, a step which by long precedent is something an appellate court will do only in the most extreme and exceptional circumstances. So let me tell you about the facts of Montgomery. She was an intelligent graduate, a graduate in molecular biology. She was pregnant with the plaintiff, her first child, and there were two features of her case which made it, as both sides agreed, a high-risk pregnancy. One, she was of very small stature, just over 5 foot. Two, she was a long-standing insulin-dependent diabetic, a chronic condition which is known to lead in sufferers' pregnancies to excessive fetal growth in the womb, which is called macrosomia. Macrosomia in these cases is, rather oddly, associated with particular deposits of fat around the fetal shoulders, which makes the baby grow with excessively large shoulders. And those features give rise together to a particular danger of the labour and vaginal delivery in mothers who are chronic insulin-dependent diabetics. The baby's after-coming shoulders, when the head is out, can become stuck behind the mother's pubic symphysis, the bone which is the front part of the pelvis. And the occurrence of this is called shoulder dystocia. It's a major obstetric emergency. It's known to occur in about 10% of diabetic mothers who labour. It requires sometimes extreme measures to overcome it, which can themselves cause injury to the mother and the baby, but worst of all, there is the likelihood that while dystocia remains unrelieved, remember the head is out but the shoulder is stuck, the likelihood is that the umbilical cord is trapped and occluded against the mother's pelvis, and therefore the baby is suffering asphyxia, and in consequence delay in relieving shoulder dystocia can mean brain damage or death for the baby. This is known to occur in about 1% of the cases where shoulder dystocia happens, although of course before the event you cannot know which among those cases will end in disaster. For this reason, McClellan, Dr. McClellan, a female obstetrician, arranged quite exceptionally for fortnightly ultrasound measurements of the size of the fetus in the womb. In consequence of the fact that they discovered the baby was indeed growing very large, or unusually large for a woman of her size, Mrs. Montgomery, as the doctor recognized, exhibited mounting anxiety about her ability to deliver this baby vaginally safely and without harm to the baby or harm to herself. And she asked more than once, in necessarily unknowledgeable terms, about those particular risks. Will I be able to get this baby out? Will the baby suffer? Will I suffer? Dr. McClellan further admitted that she deliberately withheld from the mother any information at all about the special risk that she ran, namely shoulder dystocia, and about the harm it could cause to her or to her unborn child. She even admitted that she cancelled the last ultrasound measurement because, as she put it, evidence of yet further fetal growth would only increase maternal anxiety. Instead, she chose, in her words, to allow the mother to labour and to reassure her, that was her word also, that if a problem arose during labour, they would go to caesarean section. Reassurance which was at best misleading and frankly at worst false, because if the head is out and the shoulder is stuck, you can't go to caesarean section because it's too late. The head is out and the baby's body is too far down the birth canal. It is the fact that most thinking obstetricians in the world would, in a case such as this, not only offer elective caesarean section in advance of labour, but would also advise it. And McClellan admitted in evidence that if offered it, Mrs. Montgomery would have accepted it. Quotes from her, as most diabetics' mothers do. That she nevertheless chose to withhold all information about risk and deliberately denied the mother the option of elective caesarean section, and in her charming words, allowed her to labour, was frankly mystifying, and appears to have owed more, as Supreme Court Justice Lady Hale said, to a moral objection to the proliferation of caesarean section than to any scientific justification. With hindsight, it appears that McClellan's readiness to ignore the dangers from dystocia stemmed more from the fact, or entirely from the fact, she'd personally never encountered it. Her gross underestimation of the risks and the potentially disastrous outcome was apparent from her evidence that shoulder dystocia is often overcome with the mother unaware that it's happened. An assertion which to any obstetrician who has managed the dire emergency would be truly extraordinary. So now I notice now I'm nearer the microphone. Have I been audible at the back? I have. Oh, good. I hope it's good. So it was the only delivery option offered was pursuit of vaginal delivery, and the die was cast. Labour was induced by prostaglandins and became predictably obstructed, but even when it was obstructed, McClellan did not go to caesarean section. Instead, and remarkably, she decided to augment the mother's contractions, make them more powerful and stronger, to force the baby down the birth canal by the use of the hormonal drug syntocinon. Eventually, as you all guess or know, the head delivered and the shoulder stuck, and the ensuing scenes were horrific. missed the Roberts manoeuvre, which is always required in these cases. The mother is pulled to the edge of the bed, her knees are forced back right onto her chest, and then they press down on her abdomen. It was the first thing they tried, as they have to. That's the thing that McClellan said a mother would not be aware had happened, which is, frankly, well, it's incredible in a nutshell. But that failed to deliver the shoulder. And then McClellan attempted something which I'm rather sorry to have to describe to you. She tried to sever the mother's symphysis pubis, to cut through the cartilage here in the middle of the mother's symphysis pubis, which is in the third world where they can't do caesarean section, sometimes used as an alternative to caesarean section, to open the mother's bony pelvis right out so the baby can get out. Unfortunately for McClellan and for the mother, she didn't have the right instruments and she couldn't cut right through it. So after a long delay, she decided to use forceps and managed, as she put it, with great force to pull the baby out. In that process, and you can tell I feel angry about this, in that process she avulsed the baby's brachial plexus, a known risk in overcoming this problem, left him with a useless flail arm. No sensation, no use in it. But first, much more serious. He had desperately serious brain damage, and the desperate need that he has for care and other special provision made them sue. In the litigation, I'll try and take the litigation quite shortly, the principal allegation was a lack of valid consent. What was argued was that she had been given no information about the risks or about the alternative elective section before she agreed to what was frankly the imposition, for certainly it was that, of induction and the pursuit of vaginal delivery. Very surprisingly, the defendants' lawyers argued that, according to Bolam, the expert evidence they called, and they did manage to find some which supported keeping the mother totally in the dark, meant that there was a complete defence to the failure to give any information. They argued that although the risk of dystocia was 10%, only 1% of those would end in disaster, and therefore, following Lord Bridge very religiously, they didn't see any particular reason to warn her of the 1% risk of serious harm. They also argued that when she asked, will I be able to get this baby out safely? Will I be able to push it out normally? This was not a question about the actual risks she ran, although I must say, what else was it? It was almost specific, wasn't it? About as specific as a non-knowledgeable person could be. They said that that was just an expression of generalized anxiety and therefore did not engage Lord Diplock's exception of being obliged to answer a question asked specifically with a truthful answer. Incredible as it may seem, the Scottish trial judge accepted all those defences. He accepted that they were just expressions of generalized anxiety. He accepted that there was no need to warn her or inform her of any of the risks. And furthermore, astonishingly, the appeal court judges, three of them, I'll name them, Lords Easy, Lord Hardy, and Lord Elmsley, all ending in IE rather oddly, agreed entirely with the trial judge. And I should say this, that in doing so, they were determined on one other thing. They found as a fact that if offered caesarean section, the mother would have refused it. I pause. She'd said she longed for it because she was so worried. The doctor said if she'd offered it, she would have accepted it. The trial judge, because the defence counsel argued it, found that she would have refused it. The appeal court judges agreed. Now, just pause there. The problem in Scotland is this. They're in the dark ages. Judges don't like finding against doctors. Doctors don't like finding against doctors. Judges don't like finding against doctors. Given any excuse, any absurd argument, they will find against the claimant, or plaintiff as they're called still in Scotland, in a medical negligence case. May I just quickly say that therefore we can say with complete certainty that the defence lawyers are entirely responsible for this change in the law. If as they should have done, they had admitted liability, advised their client there was no defence, which there was not, if they had admitted liability, damages would have followed, the patient would have in no circumstances needed to appeal, and Sidaway would still prevail to the great advantage of their own client, and the spurious use of it in this case would never have been exposed. Today, as Montgomery has decided, the test of whether it's approved by other doctors will be replaced by what's called the patient-centered test. Was the patient made aware before consenting of any material risks and of any reasonable alternative or variant treatments? And the test of materiality will be whether in the circumstances of the particular case, a reasonable person in the patient's position will be likely to attach significance to the risk, or the doctor is or should be reasonably aware that the particular patient would be likely to attach significance to it. There will be some exceptions. The therapeutic privilege, where you believe as a doctor on proper and reasonable grounds that disclosure would harm the patient, give them physical or mental harm. Cases of necessity where the treatment is essential but the patient is unconscious or incapable of understanding, and where the patient has expressed the considered wish not to be told about risks of treatment. The patient who says, "Doctor, I leave it to you. I don't want to hear any more. Don't talk to me about this. It only worries me." Now, the fact is this. Many people will welcome this ruling, and I think most right-minded people will welcome it. But there are those who will cling doggedly to the arguments that were pursued in Montgomery as they were in Sidaway. They will say that unreasonable difficulties are presented to doctors to decide what to tell the patient. They will claim that the generality of patients can't be expected to understand medical concepts and may only imperfectly grasp them. And they will argue that judicious rationing of information is the best way for doctors to ensure that patients consent to necessary treatment. All those arguments were before the court in Montgomery, and they rejected them all. And if I may say so and come to it, possibly lastly, I think is just a brief discussion of the way in which society's attitudes and beliefs and norms have changed over the years and were, in a sense, the bedrock of this decision now in Montgomery. It's established in UK law, as in other jurisdictions, of course, that the doctor's treatment of a patient, whether physical treatment by interventions or the prescription of drugs, is unlawful if the patient hasn't given valid consent to it. This derives from the concept of an adult human being's individual autonomy, which admits of very few exceptions, as Justice Cardozo expressed it famously in Schoendorf and New York Hospital in 1914. Every human being of adult years and sound mind has a right to determine what shall be done with his own body. Now, abuse of that principle has taken many forms. At one extreme, the Nazi experimenting on unwilling concentration camp inmates by Dr. Mengele. At the other, the well-intentioned but paternalistic attitude of doctors who deliberately override and historically have regularly overridden the free will of patients by deciding for them and effectively imposing treatments upon them, such as the doctor knows best principle. Take these pills, or we're going to cut off your leg. An approach which Montgomery says is no longer acceptable. Doctor knows best used to be accepted everywhere. It belonged to the historically prevailing culture of subservience to those in authority, the age of deference, or those of greater learning. It also owed itself in part to generalized ignorance and even awe of the wondrous science of medicine. The awe was founded, it seems to me, also in part on a sort of fatalistic acceptance of the cruelty of disease and its often inexorable course, and the associated belief, historically, born of scientific ignorance, that when doctors effect cures, it's by the practice of a quasi-magical art, which is not for mere mortals to understand or question. If those beliefs persist today, it's to a very limited extent only, and largely among the elderly and less educated. Yet, the law in the UK and the common law, which is followed here, as it's historically been applied, is, in my view, very largely the product of those, to modern minds, outdated attitudes. They're no longer societal norms. They've been displaced by greater education and by the vast and accessible internet and media publicity for and dissemination of knowledge about modern medicine and its advances in so many fields. We're all our own experts now. For consent, it was time to consign Bolam to history, as other jurisdictions have done. A major focus in Montgomery, as I've touched on already, was the dissenting opinion of Scarman in Sidaway. He relied in particular on two cases from America and Canada, Canterbury and Spence in 1964, in which it was said, respect for the patient's right of self-determination on particular therapy demands a standard set by law for physicians, rather than one which physicians may or may not impose upon themselves. And the famous judgment in Rebel and Hughes in the Canadian Supreme Court, when they said, that the issue of patient consent is a different issue from that involved where the question is whether the doctor carried out his professional activities by appropriate professional standards. Under consideration here is the patient's right to know what risks are involved in undergoing or foregoing certain surgery. In Australia, they rejected Bolam in consent cases in the famous case of Rogers and Whittaker. Just in very simple terms, a lady was blind in one eye, had been from birth. It was rather cosmetically unattractive. She asked the surgeon, could he improve the look of her blind eye, and he said yes. She asked, were there risks? He said no. There was in fact a risk, I'm sorry to tell you, and you'll have guessed it materialized. It was a very small risk, 1 in 14,000 roughly, that if you operate on the blind eye, there might be sympathetic ophthalmia, and the good eye would go blind as a result. You guessed that it happened, of course, and the judges in Australia entirely rejected the Bolam defence, although doctor after doctor or surgeon after surgeon gave evidence in support of withholding that one tiny risk from this patient. And the judges said, because the choice is the patient's, it is in reality meaningless unless it's made on the basis of relevant information and advice. Because it calls for choice to be made by the patient on information known to the medical practitioner but not to the patient, it would be illogical to hold that the amount of information provided by the doctor can be determined from the perspective of the practitioner alone, or for that matter, of the medical profession itself. I've gone on a long time and I've strayed a bit from my script, but let me say this in conclusion, a couple of things. One, the fascinating thing is that this, what I've described as the change in societal norms, the attitudes of the population in general, has long been reflected in the English General Medical Council rules for the profession of medicine, for the practice of medicine. I need only go back to 2008 and tell you that in that year, in a document known as Consent, Patients and Doctors Making Decisions Together, the GMC, in terms which in their preamble say are mandatory, say the doctor may recommend a particular option but must not put pressure on the patient. The doctor explains the options, the potential benefits, risks, burdens and side effects of each option, including that to have no treatment. A doctor must tell the patient if treatment might result in a serious adverse outcome, even if the risk is very small, and should tell the patient about less serious complications if they occur frequently. The GMC intervened in Montgomery and made submissions to that effect. I don't quote more. There are many passages which show that the General Medical Council, who are the regulatory body in England, had strongly endorsed and indeed made mandatory full disclosure for quite a number of years, and yet the law had lagged behind. Now, I have said that it's patronizing, condescending, and inconsistent with patients' rights to withhold knowledge about risks and to withhold information about outcomes, whether adverse or not. And I've said that it's repugnant to modern thinking. I know that not everyone will agree. In particular, when I face the doctors, as I do tomorrow, I expect to get a good kicking for it. But the fact is this. We have to bring the law into line with what we are now accepting as the norm in society. Lord Diplock's views that he, but only he and his like, should be allowed to make up their own minds whether to accept or refuse treatment is simply unacceptable today. What I contend is that, frankly, as you've already gathered, is that Montgomery should pave the way for the gradual, as I'm bound to say it will be, disappearance of Bolam in its extreme and express sense, namely, if you can find a small, even a very small body of medical opinion which supports it, it's a defence. Bolam must be undermined and must go. At the same time as accepting, as I always have and always will, that acceptability to your own profession must be relevant to the judge's decision. And indeed, sometimes it will be decisive to the judge's decision. But it must not be a matter of arbitration by doctors as judges in their own cause. We must restore to the judges their proper function in deciding these cases. I should say this finally, that I had called to my attention only at the end of last week after I'd prepared this lecture, that on the 21st of April last, which is just over a week ago, Lord Justice Jackson gave a lecture in London which is entitled The Professions, Power, Privilege and Legal Liability. It was the Peter Taylor Memorial Lecture, and it's well worth a look. He spoke of the fact that Bolam was the only exception to the general rule that the Bolam test would not apply to professions generally over the years. Medicine, he said, has been the last stronghold of it. What he said was, about Montgomery, now that the invaders have broken through the castle walls, they will not stop there. How right he is. I predict that over the coming years there will be a continuous onslaught on Bolam. The argument will be that the ordinary principles of tortious liability should apply to the professions in the same way that they apply to everybody else. There is no reason for the courts to accord special protection to the professions. He adds, very tactfully, because he is an appeal court judge in England, whether those attacks will succeed, I do not know, and it would be wrong for me to predict. I merely state where I foresee the next battle being fought. And I hope perhaps you'll join me in the road to fight those battles, and I hope I haven't taken up too much of your time. Thank you.
Thank you, Mr. Badenoch. Well, anyone reading the case might notice that, in fact, I'm sorry. I should invite the panelists to come up. I think, can you get up there? Yeah. One of the remarkable aspects of this Montgomery case is that the child concerned was born in 1999. So it took a very determined mother and a very determined counsel to bring this case to fruition. And I, of course, am very glad as a lawyer that Alex Salmon and the Scottish vote failed. Otherwise, well, it would not have fallen to be decided by the UK Supreme Court. Now, we will just spend the next half an hour or so in a panel discussion. I will first invite Professor Lemark and then Mr. Chris Howe to give their views, maybe perhaps 5 minutes each, on what they think might be an appropriate response by the medical profession to this Montgomery case, and any other comments that they may want to make in relation to the impact of this case. I might also invite you to consider what might be the impact of this case for consents in the clinical setting as well as in the research setting, because, of course, consents ultimately deal with disclosure. So to start off with, Professor Lemark.
Thank you. Well, I'm very happy that the courts have caught up with us. We're 4 years ahead of you. I just read out more than that, 5 years, because the Code of Professional Conduct of the Medical Council of Hong Kong, 2009, already set out what essentially is the Montgomery decision. And that is consent to medical treatment is part of quality care and also a legal requirement. So consent has to be given voluntarily by the patient after having been informed of the relevant aspects of the medical procedure, including the general nature, effect, and risks involved. And I skip a few paragraphs, and the last paragraph here is a patient has a right to refuse to give consent to treatment, provided that the patient is able to exercise his judgment clearly and freely. So let's fast forward to 2011. We came up with a promulgation which flesh out some of the general principles stated in the code. And the promulgation in October 2011 says the following: consent is valid only if it is given voluntarily, doctors provided proper explanation of the nature, effect, and risk of the proposed treatment and other treatment options, including the option of no treatment, and the patient properly understands the nature and implication of the proposed treatment. And after the explanation, and this is very important for elective cases or non-urgent cases, after the explanation, the patient should be given reasonable time to enable the patient or his family members to make the decision properly, so a cooling off period. And now, proper explanation. So we spelled out what constitutes proper explanation further. Explanation should be given in clear, simple, and consistent language. It should be given in the terms which the patient can understand. The explanation should be balanced and sufficient to enable the patient to make an informed decision. I think there are questions from the floor. We did have a case like this recently in inquiry. A doctor should not withhold information necessary, and that's exactly Montgomery. A patient should not withhold information necessary for making a proper decision for any reason, even if the patient's family members ask for that. And the threshold for withholding necessary information for making an informed decision should be very, very high. And a doctor who withholds from the patient information necessary for making a proper decision must record the reason. So now, further down the line, at a later date, in December 2012, there was a coroner's inquest in the death of a patient after surgery. And there was a recommendation from the coroner's court, by the jury of the coroner's court. One, the doctor be required to explain to the patient and set out in a consent form in details the nature, effect, risk, and complications of the proposed operation. So it must be written down. And the consent form should be signed by the patient, the doctor, and the witness, all at the same time, not one after the other. That's bad practice, but it's still being practiced in many hospitals at the moment. So that's basically where we are in 2012. And I personally think that, and I agree with you, that Bolam should go. I've seen atrocious, let's say, bad medical practice with terrible effects on patients. And we couldn't do anything because of Bolam. And I think for the two other limbs of Bolam, we should really try to at least dilute it a bit. Thank you.
Thank you, Professor Learmonth. Mr. House?
Thank you. Well, Professor Learmonth helpfully covered a number of points I was going to make. Certainly, in front of the Medical Council, I have the pleasure of appearing in front of Professor Learmonth on a regular basis. Bolam has not worked for years. I have been roundly thrown out on a number of occasions. What do I mean by that? What I mean by that is when you're in front of the Medical Council defending a doctor, because I'm on the side of the angels, I'm with the doctors. What you're seeking to do is show that what a doctor did is in accordance with acceptable medical practice. Their treatment has not fallen below an acceptable standard. That's what you're trying to demonstrate. And one way in which I have over the years tried to demonstrate this is by producing one of the great and the good of Hong Kong, who would say exactly what I would have done, absolutely nothing wrong. In fact, this is the way we teach it in our hospital. And I have to say, I don't think I've ever succeeded in that. So certainly Bolam in front of the Medical Council, I think went a long time ago, certainly 4 or 5 years ago, and probably longer than that. And probably no bad thing. What I wanted to go on, obviously I look at it slightly more from a the defence lawyer side of things, what is it all going to mean? If you throw away all the tests that we had in Bolam and Bolitho and Sidaway, you're looking at what a responsible body of medical doctors would do. So you get one of the great and the good to say, there's absolutely nothing wrong with this, so it's part of the acceptable practice. What is now going to happen? What we're going to have to show with a doctor is that an adult person, I'm quoting from the judgment, of sound mind was entitled to decide which of any of the available forms of medical treatment to undergo. So you've got to deal with the alternatives. Consent had to be obtained before treatment interfering with the bodily integrity was undertaken. Fine. Therefore, the doctor was under a duty to take reasonable care to ensure the patient was aware of any material risks involved in the proposed treatment and any alternatives. None of this percentage nonsense, that all goes out. Now, so far, so good. The next bit is, I think, the bit that's going to give us pause for thought. The test of materiality was whether, in the circumstance of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor was or should reasonably be aware that the particular patient would be likely to attach significance. That's quite tricky, because we no longer want one of the great and the good to tell us this is acceptable. What you almost want is half a dozen people walking past Alexandra House to say that if they were in that position, that's exactly what they would have done, because they're normal, average, sensible people, like all people in Alexandra House. What in practical terms are we going to do? Doctors' records will be vital, medical records will be vital, what's in the patient's notes will be vital. Now, we teach all the medical students that anyway, and sometimes they believe us. Witnesses to the consent process would be vital, because you don't want to have doctor against patient. The doctor's always going to lose. So you want someone witnessing the consent process who can say, I was there when Dr. Smith went through this. I can tell you, because I signed off on this form, I can tell you they went through the alternative treatment. I can tell you who went through the alternative risks. There they all are written down. So you're going to want someone else there. Forms won't work. We've all drafted those. Anyone who's a defence lawyer has drafted these. So having an 18-inch form with a signature at the bottom is no good. There will be cost implications, obviously, because you have to move. I've read many times, I've never been a GP in private practice, but I've read many times that the average time for consultation is 6 minutes. And that's driven by economic necessity. If he doesn't do it that quickly, the doctor next door will, and he'll lose all his patients. So if you're going to start consenting people in more detail, and clearly a sensible thing, there is going to be a cost implication. It's going to take longer. And you must put it in your notes. Your notes have got to protect you. And there has to be some balance to this. I did one case in front of Professor Learmack, where we were dealing with a procedure, and the opposing expert, who's some terribly eminent person, was criticising the consent process that our doctor went through. And so he said, fine, could you just take us through what you would have done? And off this particular expert launched, and we timed them, 36 minutes. Now, it was pretty much the university thesis of what you could have done, 36 minutes of explaining. That is an awful long time. It's going to be quite expensive doing that. Was it all necessary? In my view, no, it wasn't. But you are going to definitely develop a culture where consent, and in particular the documentation of consent, is going to be more and more and more important. You must have someone present. They must sign off, and you must be able to, without recourse to your memory, go through exactly what you advised. What else? Sadly, for the many of you in the audience who've acted as experts, there'll be a little less expert work, because we won't need quite so many of you to say what is and isn't the appropriate standard. So I think it will create a change. I think it's a good thing. You read the decision, as I'm sure most of you have done, and as Mr. Badenoch was saying, you are astounded that people could possibly not have found in favour of this plaintiff. It's the most horrendous case, and perhaps it needed a horrendous case to achieve this result. The one point that I would like to raise, which I'd be very interested in Mr. Badenoch's view in due course, is the fourth limb to the head note, which I didn't read out, which is, however, a doctor is entitled to withhold information as to risk if he reasonably considered that its disclosure would be seriously detrimental to the patient's health or in circumstances of necessity. Now, circumstances of necessity, I understand. Someone's unconscious, they're blind drunk, they can't give you valid consent. That's easy. But I'd be very interested in Mr. Badenoch's view as to the circumstance in which disclosure would be detrimental to a patient's health. Because having seen a decision like this, I'm not sure I would be saying to a doctor that there is anything I would withhold. Give the patient the lot. And similarly, if you've got a patient who says, as Mr. Badenoch was saying, an old-fashioned patient, doctor, I trust you. You know, you're wonderful, I trust you completely, please don't give me the gory details, I can't cope with them. I think you would have to say to that doctor, no, that's not enough. You must insist on going through it. The patient may not like it, but you must insist on doing it. It's the only way to protect you. But I would be very interested at some point in this discussion as to what might justify withholding information, because I think for the doctor that would be dangerous.
Thank you, Professor Lindmark, and thank you, Mr. House. Mr. Badenoch, you have a right of reply.
I have quite a lot of thoughts about the practical difficulties which may be presented to doctors. Perhaps I ought to just say this. I don't think that the law, the judges and the law, in applying Montgomery, need apply it unreasonably. There will be constraints on doctors' time. There will be doctors who are less good at explaining things than others are. And there will be patients who either don't want to hear or don't readily understand. What I think I ought to do perhaps is run through the advice that I'd prepared to give the doctors. And perhaps some of it will help answer the queries. I'm proposing tomorrow when I go into the Lion's Den with the doctors themselves to say this, that the pro forma approach to consent must obviously be abandoned, and it's a good thing that it is. The signature on the consent form, and often, you know, they send the youngest doctor and say, get the patient to sign this. It's the norm almost in many places. The signature proves nothing except that the patient can write his own name. What is required now is a dialogue, and in discussing the risks and benefits, what Montgomery is saying is you must ensure you use words the patient understands. You must and can, of course, avoid overloading the patient with detailed information. You keep it simple, unless it's Lord Diplock. Actually, he's dead now. You tailor your decision to the individual patient, and that's quite straightforward in my view. It means you consider this particular patient and his characteristics. You have to ask yourself, obviously, and you do this and you make a note of it, is this patient a very anxious person? Is this patient a very a highly intelligent person with a very great intellectual interest? Or is this a patient who would probably, if I gave him very technical discussion, would be quite unable to follow it? You're allowed latitude. I think the courts will exercise this power over doctors reasonably. You're told that, for example, in the therapeutic privilege, as it's called, in Chris House, sorry. Yes, I ran across a doctor called Michael House. Is he related?
No relation.
What Chris House wonders is about therapeutic privilege. When will it be the case that the doctor will be entitled to say to himself, this patient will suffer harm if I tell him about the risks? I suspect there'll be very few and far between such cases, but I can envision an instance in which the patient is of an extremely nervous disposition, perhaps a patient with either serious or at least very noticeable psychiatric problems. For example, a suicidal patient, one who has had bad experiences with doctors in the past, whatever it may be. I think you'll find that those very rare cases will probably define themselves. Here's a case where I better be very careful, because if I tell this patient that the possibility of the surgery which I'm saying she really needs to have might leave her paralyzed, would leave her so terrified that she would not be easily able to cope with it. I think that's what the therapeutic privilege amounts to, and I think it'll be the very rare case. There will not be so rare the cases, I think, when patients either expressly or by clear implication make it clear that they don't really want to hear. I mean, I was speaking to a very distinguished member of the legal profession yesterday, who said that his approach was, well, I've only gone to the doctor because the doctor's the expert. It's up to him to decide what's best for me, and I'll leave it entirely in his hands. The doctor can very rapidly discover if that is indeed the patient's position. Indeed, probably should discover it's the patient's position. So I don't think that presents problems. The issue of being sensitive to the characteristics of the patient, which is an expression from Montgomery, does put a burden on the doctor. I mean, a classic and easy illustration of this would be, let's take a first-time mother who's never been pregnant and never had a baby before. With her, you must be sensitive to the fact that she may be very frightened, she's likely to be very ignorant, she may have heard all sorts of scare stories or watched those television programs in which women scream and scream and scream, and be completely convinced that it's going to kill her. With her, you'll have to be very sensitive and careful. Different for the mother who perhaps has had 2 or 3 children already. When you're discussing the options for her delivery, you can probably be very frank and very open about the risks and about the process that you prefer. I think that last word I've used, the process you prefer, is probably the key to this for a doctor. In the end, most of us, when we're facing a worrying decision, let's assume, because this is where it matters, that we're seriously ill and treatment is essential in one form or another for us, and we're conscious and perfectly capable of understanding what the doctor's saying. I think that the real issue will be, am I having a reasonable dialogue with my doctor? And part of that will be this question. Doctor, if it were you, what would you do? Or if it was your son, daughter, or wife, or some close relative of yours in my position, what would you do? And if the doctor bears that as a really quite important consideration in mind, he may be able to short-circuit a lot of this difficulty. He won't have to be a clever psychiatrist or psychologist. He will be able to say, look, we've got to do something about you. There are a couple of alternatives. One is slightly less effective but carries no risk. The other is more effective and carries a small risk. Let's take an aneurysm, the investigation of an aneurysm. Some surgeons would say they want to have the invasive catheter test, whereby they push a catheter up from your groin right up to your neck or head and then inject the fluid and get a really good map of the brain for the operation they've got to do. Alternatively, you can have the less invasive MRI scan of your brain, which isn't quite so definitive. And you could say to the patient, look, if it were me, I would go for the one which carries some risk. It's up to you. The other is probably pretty good and will give us a good idea. But if I were you, or if you were my wife or son or whatever, I would do X or Y. So let's be reasonable about it. The man on the Clapham omnibus trying to think for judges trying to work out what Lord Diplock could never work out what the man on the Clapham omnibus would think. He was far too intellectually superior. But judges have not had great difficulty working out what the reasonable man test is in other fields. I don't think it should be too difficult for doctors to see what the reasonable patient test is.
Thank you, Mr. Badenoch. If I might just impose on the audience to just take 15 minutes for the Q&A. If you can identify yourself, introduce yourself clearly and use one of the microphones which will be handed to you. But as chairperson for now, I will use my position to exercise the privilege of asking the first 2 questions of Mr. Badenoch. The first is that autonomy sounds all very well in theory, but at least in Eastern Asian societies, it may have complications. For instance, it's very frequently a very elderly person sees the doctor not by herself or himself, but with her entire immediate family. They go and see the doctor in the doctor's surgery. So what if the elderly person says, well, don't talk to me, talk to my eldest daughter, talk to my eldest son. And sometimes the family doesn't want the elderly patient to know. So that's the first question. What do you do in that kind of situation? The second question relates to Lord Scarman's arguments in Sidaway. He was quoted with great enthusiasm in Montgomery. But one of the principal arguments which Lord Scarman raised in that case was his contention that failure of informed consent should lead not to an action in negligence, but to an action in trespass to the person, which makes it easier, actually, for the patient to succeed?
The difficulty in a different culture of coping with conventional ways of behaving, it seemed to me to be a matter not just for the local medical profession, but for the local lawyers and judges in the end to deal with. I suspect that those cases to which you refer aren't unique to the Far East, and I think in England we also have the classic picture of the old lady escorted to the doctor by her daughter or son, in which the daughter or son said, look, talk to me about this, doc, because I don't think she really wants to hear much or may not understand or whatever. I think if it's sensitively handled, and if you establish quickly and sensibly that this is really what the patient is happy with, then just make a note of it. Make a note of all this. I agree with Chris House about this. Make a note of whatever happens if it presents a problem to you. But I think the doctor is quite entitled to say, the family came en masse. There was a request that I talk about risks and benefits with relatives and not with the old lady. And I briefly discussed that with her herself, and she was happy for it. Now, that would be a defence to that, I think. As for the trespass issue, that was an issue raised frequently in the early days of medical negligence cases in the UK. It was roundly rejected as the appropriate, as the tort, which should be relied upon by high authority fairly rapidly when doctors were accused of trespass to the person. Technically, I think it must be right that if they do something without your full and valid consent, then it's assault and battery. And indeed, there are old cases in which that principle was espoused. But as a matter of public policy, the courts, I think, effectively ruled it out and said, look, it's quite inappropriate to accuse a doctor effectively of an assault when he's doing something clinically relevant and intentionally therapeutic, albeit that he didn't get valid consent. So I think Scarman was looking at a problem which had raised its head, but one which the courts have effectively scotched by saying, look, don't do it, don't go down that road because we won't wear it.
Thank you. Professor Lindmark.
I have very strong feelings about applying cultural relativism. I think if you look at Shakespeare and you look at Shylock, if you prick me, I will bleed. If you insult me, I get angry, and so forth and so on. So basically, we are human beings, and we should respect the autonomy of that human being and not hide behind the curtain of cultural relativism. Just because we're Eastern doesn't mean that the patient in front of us does not have autonomy, which we have to respect. And I think it's a poor excuse to say that there's a cultural difference. There's none.
Thank you, Professor. Questions from the floor? Would you please introduce yourself?
Nicholas, I'm a solicitor and I act for plaintiffs in PI and medical negligence actions. I have two questions, the short one for Mr. Badenoch, and it's quite simply, to what extent do you think the reasonable doctor may be eventually supplanted by the reasonable judge?
I find that question. I find that question quite difficult to answer, because in one sense, what this will come down to is what the judge thinks would have been reasonable. I mean, the ordinary test of the man on the Clapham omnibus is the judge trying to second guess what that fictitious person would have thought. So I mean, although when you phrase it like that, it sounds slightly absurd, the truth is the judge will, in the end, have to put himself in that position as best he can. Of course, the patient, when the patient has sued, will give evidence of what he or she personally would have wanted in her situation to know. By implication, of course, the litigation will only be happening because they weren't told it. So the judge will have what that person him or herself said, and then the judge will have to, as you rightly imply, take on the persona of the reasonable patient. I don't think I can say other than that. I think it's what happens. You won't have lots of reasonable people coming to court and saying, I'm a reasonable man. I'm a reasonable man, and what I think is X.
Let me put it the other way. To what degree do you think the defence will seek to challenge that the particular patient who has brought the action on a consent basis is not reasonable?
Could I just, before I answer that, say this, that Montgomery and indeed the GMC themselves in their submissions made the very forceful point that if you are open with a patient before you go into something which carries some possibility of adverse consequences and some major or minor risks, if you've been open with them and frank at the beginning, there is much less likely to be that miserable unhappiness and recrimination which follows when a bad outcome happens, with the result that there is in fact likely to be less litigation, not more. I happen to think that's almost certainly true. I suspect that if there is litigation, it will focus on whether any of the proper exceptions to the case apply. The patient who really clearly wasn't capable of understanding properly, the patient who clearly, expressly or obviously didn't want the doctor to go into any of that, and there are plenty of people still like that, especially among the older generation. And finally, I think it'll probably centre, as you imply, on an argument as to whether, in the particular circumstances of the case, telling the person of a 1 in 14,000 risk would have been a reasonable expectation by this patient. The lady blind in one eye, having a totally unnecessary, purely cosmetic operation, yes, very reasonable to tell her about a 1 in... A blind silk in London stood up when we had a big meeting, just as we're having here, about that Australian case, when Lord Justice Jackson said the judges in Australia have gone mad and they ought all to be sacked. Up stood the first questioner, who said, an old silk, an English silk, and he said, not a lot of you know this, but I'm a one-eyed man. If I was having an operation on my blind eye, which was purely cosmetic, and there was a 1 in 10 million risk of losing the sight in my good eye, I would have wanted to know, and if I'd been told it, I would have refused the operation. So there, in that case, the tiny risk, totally reasonable to tell him. In another case, a tiny risk of that proportion, a doctor would legitimately say in our developed societies, look, it was ridiculous to suggest that I should have told the patient about that. In the particular circumstances, it was unnecessary and unreasonable. The fact that it has materialized is such an extraordinary bad luck that it was better not to tell him than to tell him.
Thank you, Mr. Badenoch. The gentleman over there.
Thank you. Chris Hui, Hong Kong U. Thank you, Mr. Badenoch, for a delightful and vivid illustration of this landmark case. When the terrible events of Montgomery versus Lanarkshire occurred on the 1st of October 1999, I was but a house officer. I was a practicing clinician over the last 16 years. I've seen the transition from Bolam to Montgomery, and I'm be the first to declare that I'm in support of this, especially after a career having seen a small, unfortunate minority of our colleagues practice in perhaps, like you say, idiosyncratic ways. It is all about protecting the patient at the end of the day, and I think the medical council and the courts have a duty of care. My question is slightly more oblique, though. I'm concerned about the sort of more elective side of clinical practice, where there is an option to do or not to do. In the face of increasing sort of legal challenge, there is the risk that, particularly those of us who practice more on an interventional level, there is a withdrawal from sort of what is perceived to be higher risk activities in deference to sort of effectively the judgment of the courts and sort of outcomes of cases in similar field. The problem is really avoidance of risk, and the idea that we practice in a world of absolutes and ones and zeros. It doesn't exist in my world, unfortunately. But my my concern is that we are then entering an age where potentially you are discouraging clinicians from taking necessary risks for the best in order to achieve the best outcome for the patient.
I respect that argument. Well, I must say I respect also the arguments of Chris House as well, of the difficulties that are presented. I think this one comes into the same category as the argument about defensive medicine, that litigation will make doctors practice defensively. I should say straight away that I think most patients who face serious interventions will be rather glad that the doctor takes extra precautions because of the fear of litigation, rather than just a cavalier approach. I think that the doctor who feels strongly that a potentially risky treatment is nevertheless heavily weighted as a benefit to the patient will find it a heavier burden upon him now to get that across. I appreciate that in some cases there will be patients who, when the doctor does get it across, refuse it, as the doctor would say, foolishly, and not in his own best interests. But that seems to me to be the problem, rather than that the doctor will avoid advising it. Because if the doctor now practices in a culture where he's obliged to discuss it in a dialogue, given I know, and Chris House is right, time is so limited, particularly for GP consultations, but the doctor knows he has to talk about it to the patient. He knows that he must be frank with the patient, and the case which some of you may or may not know that I did, which was in a sense a bit of a precursor to Montgomery, was called Birch and University College London Hospitals Trust. I'll explain it. The lady had, she was another long-standing diabetic, and she had a problem with her eye, a painful pupil sparing palsy. The likelihood was, from her past history, that she probably was simply having a vascular problem from her diabetes, which would be self-limiting and self-recovering. The original consultant said, have the MRI scan. She ended up in the National Hospital for Neurology in Queen Square in London, the famous place full of brain surgeons, and unfortunately under the surgeons, not the physicians. And they said, well, we thought she might have an aneurysm or something very nasty going on behind the eye and in the brain. We wanted to have the absolutely definitive map of what was happening in her brain, so we told her she must have the invasive catheter angiogram. And of course, you've guessed, she suffered a stroke and was paralyzed down the right side of her body. And she rightly argued that she didn't need it, that actually the most overwhelming likelihood was that it was a diabetic retinopathy, or whatever the word is, and that she therefore should have been given the non-risky, non-invasive test. That pointed up the point you're making. They didn't actually need to do the really risky one. But they had a very legitimate argument that in many such cases, which actually are self-selecting, because usually by the time they've ended up at that tertiary referral centre, it's because everybody suspects something really nasty, when it really is necessary to do the absolutely definitive test, although it's the risky one, they've got to get that across. And they ought to have the courage of their convictions. That's what I'd say.
At the back.
I'm Mary Lee, a clinical psychologist. I'd like to respond to a question about when to justify not to disclose. I used to work in a public hospital in Hong Kong, and some good doctors really refer patients to me when they encounter a situation that the relatives requested the doctor not to disclose bad news to the elderly. And usually, after seeing one session with the patient relatives, it usually is the case that it is the relatives' anxiety instead of the elderly's problem wanting to know. And so I think it's really a matter of communication, understanding what is the barrier behind the fear of not disclosing in the perspective of the relatives, instead of just a closed case, just with, following the relatives' advice or preference. This is one situation. The other thing is about whether the patient is too anxious. I do believe that we do have to dig into the anxiety, the causes of anxiety when patients seeing the doctors. I mean, instead of just justifying that this is a depression case or anxiety disorder, that the patients should not know, or better not to tell them.
Thank you.
I do believe that, I mean, the change in this legal practice, I do hope that there will be some kind of positive change in the medical communication culture between the doctors and the patients. And really, it takes time to communicate with patients, and it does worth it.
Thank you. Perhaps I will invite Mr. Badenoch and perhaps panelists to answer this.
I thought perhaps Felice should have the first shot at that.
Thank you for that, James. I think it's an illusion. Most of the time, the elderly patient would have some idea of what is happening. They're not dumb. They're pretty astute. Some of them may be in denial, so they don't want to know. I think the anxiety is more on the part of the relatives. Mom will collapse if she knows. But mom is pretty tough most of the time. She can cope with the diagnosis of cancer. So don't underestimate. That's why I usually think, we do have some prejudice. Both of us are pretty elderly, but, against the elderly, they're not really that tough. They're frail. Oh, come on, they survived 70 years. They must be pretty tough. The second is the relatives are being paternalistic. They're depriving the individual of the right to autonomy. And I think we should consider that. Yeah,
well, I can't really add anything to that. I don't know whether Chris, from his slightly different perspective, has a different view.
My view, I'm afraid, is always the same, whether the answer to the gentleman's question there or to yours. You better be able to justify what you did, and that had better be in writing. And it's because my team, who's out there with David in the audience and we're dealing with this day in, day out. It is actually very difficult to write when you're giving advice. Try it. It's extraordinarily difficult. You're sitting there talking to a patient. You're meant to be writing at the same time? Or do you wait to the end of the consultation and then write it up? You're going to have difficulty doing that too. And I can absolutely guarantee that what the patient said at the time is almost certainly not what the patient is going to remember they thought they said 2 years later, because there's always a time gap. It's no one's fault, but there will be a time gap, whether it's medical counsel, civil proceedings, coroner's inquest. It's a time gap. And you really, where I think we're going with this is you're going to be doing what a lot of dentists do now. You're going to be DVDing it. You're going to be recording it. So you are, first thing, of course, is you're going to get a patient consent to record it. Otherwise, you've got a problem with the Privacy Commission. But that's the least of your concerns. What you're going to end up doing is you're going to end up saying to the patient, now it's very important we go through this consent process. It's very important we both have a record of it. So I'm putting on a DVD. And you record it. You have someone else in the room with you, and you go through it, whether it's from a prepared text or whatever, and you explain it in simple terms. You make sure you're not confusing them. And then often, I heard someone lecture about this ages ago, I can't now remember who it was, the best way to do it, if you want to understand what the patient has and hasn't understood, is you give the advice, you turn around to the patient and say, right, do you understand that? Of course, the patient nods. Fine, repeat it, please. Tell me what I've just told you. If they can't, they didn't understand a word. It's exactly the same with lawyers. Everyone listens to us, they don't understand a word we say. But we have the advantage in that if we advise you of something over the telephone, we confirm it in writing afterwards. I mean, that is our standard practice. You phone up, you ask for advice. You'll get an email confirmation of that advice within half a day. It also protects us. We've got a record of what we told you. But I think what everything I've heard this evening tells me is you are going to have to record things better. And I think you'll end up doing it by DVDs. I'm not entirely convinced with this idea that the more we do this sort of thing, the less litigation there's going to be, because I would have thought America is the prime example which disproves that. It's where you have banks of lawyers. And on one occasion, I think when we were trying to justify the fees that GPs were paying to the Medical Protection Society, we gave an example of a GP in Texas whose equivalent subscription, this is about 15 years ago, was $135,000 US a year. And that was statistically 1/3 of his income, because he assumed that 1 patient in 3 would sue him. So he had lawyers and equipment, the whole lot, and huge amounts of insurance.
I should tell you that 50 years ago, all my family, on both sides, are medical or surgical. So much so when I was a little boy, I used to say, when I'm a doctor, because I thought that when you grew up, you were a doctor. My gynecologist uncle in New York and my father, more than 50 years ago, I heard them roaring with laughter, and I asked them what the joke was, and they just discovered that my uncle's insurance premium in America was a good deal more than my father's entire salary as a consultant in the National Health Service in England. Well, I mean, there are lots of doom and gloom stories, and doctors, some of them, are up in arms about this. It'll shake down. Doctors will have to find a way, as they always have. And remember that the Bolam principle does not, and has not for a long time, applied in other jurisdictions in the world. England, Ireland, Hong Kong. Well, I don't know what other exceptions were, but they are almost alone in allowing the doctors to decide what is reasonable to tell a patient. Just remember that when you think that this terrible development in the law is going to cause absolute chaos. No, it won't. No, nor should it.
Thank you, Mr. Badenoch. I think we have really run out of time. Should you want to further listen to him, we have another session tomorrow at the Hong Kong Academy of Medicine. So if you want to frighten or enlighten a medical friend, as the case may be, you can bring her or him along. For those of you who are interested in reading the Montgomery case, we will be making available online on the CMEL website a link to download the full text of the case together with a summary of the case. Now, will you please join me in expressing our thanks to Mr. Badenoch, Professor Mark, and to Mr. House. Now, I really also would want to express my the center's gratitude and thanks to our supporters and sponsors, who are the Hatton Trust, and in particular, Dr. Ron Zimmerman. Dr. Zimmerman? And also the Wing Foundation and Dr. Anthony Ng, without both of which trusts. And gentlemen, we will not have Mr. Badenoch here with us today. So thank you so much.